I'm a hand, I'm a habitual,
My youngest son.
One of them's mine,
He
so
that's just how he
okay.
examines things and stuff.
22. I'll go ahead and call the local government full committee to order. At this time, Madam Clerk, will you please call the roll?
Representatives Calfee, Carr, Chisholm, Gant, Helton, Hodges, Holsclaw, Leatherwood, Love, Manis, Miller, Moody, Moon, Reedy, Rudd, Shaw, Williams, Vice Chairman Wright, Chairman Crawford.
Here.
Mr. Chairman, you have a quorum.
Thank you, Madam Clerk. Does any of the members have any personal orders or announcements? Seeing none, we'll go ahead and get started. We have 7 bills on the calendar today, 2 bills on special calendar. At this time, I'm going to, without objection, roll House Bill 1201 to the Hill. Item number 2 on our agenda today is House Bill 645 by Chairman Faison. Proper motion and second. I do see it has an amendment. Can you please give us your drafting code?
Thank you, Mr. Chair. Committee, the drafting code of this amendment that does write the bill is 017248.
Got a proper motion and second on the amendment. Since the amendment rewrites the bill, we'll go ahead and place that on. All in favor, please say aye. Opposed, no. Bill's now amended. Are we not taking up 16414? Okay, let's go ahead and, I have a drafting code for 016414. It's an amendment by Chairman Carr.
Thank you, Chairman. This bill this bill, if this bill passes, would take out Sevier County and Sullivan County. And then with that, I ask for motion on the.
Do I have a motion and second on the amendment? Proper motion and second. We'll go ahead and place this on the bill. All in favor of drafting code 16414 going on the bill, please say aye. Opposed, no. Bill's now amended. Chairman Faison, you're recognized on your bill as amended, sir.
Thank you, Mr. Chair. Good morning, committee. In 2020, we passed an Airbnb bill that made some mistakes. The way this bill is now currently amended, it's an attempt to fix those mistakes, and I'll just tell you briefly what it is. The original intent of the legislation in 2020 was to allow for a person to transfer their property and maintain a grandfather short-term rental permit in the following 3 instances: a transfer one spouse to the other, a transfer as a result of divorce, or a transfer from an owner to a trust or from a trust back to the original owner. As the current law stands, the above 3 instances are the only time when someone loses their grandfather status, making other types of transfers lawful. This has caused people to lose their grandfather protection because they in good faith transferred their property and now are being told they have to cease to operate. The amendment makes clear that only in these 3 instances listed above may a person transfer their property and retain their grandfather status. Then finally, Section 2 of the new section is the law to create a 1-year window for anyone who has lost their grandfather status in the past as a result of our drafting mistake in 2020. And that's what the bill does.
You've heard the explanation of the sponsor on the bill as amended. We do have a speaker that we need to hear from. Without objection, we'll go out of session and hear from them. Out of session. Will Kayla Anderson, will you please come to the table? Please identify yourself and who you're with, and you have 3 minutes. Whatever you feel comfortable, ma'am. Just make sure the red light's on where we can hear you.
Good morning, and thank you so much for having me. My name is Kayla Anderson, and I'm a PhD student at Vanderbilt University in the Community Research and Action Program and a resident of Davidson County. And I oppose House Bill 645, a bill which seeks to deregulate short-term rentals by redefining what is considered an owner-occupied rental by no longer requiring the owner to live on the property, but rather only have the intention of returning. This bill not only strives to deregulate short-term rentals, but to remove power from local municipalities and communities. For the past 3 years, my colleagues and I have been researching the impact of short-term rentals on Davidson County and began our work by examining previous studies on the topic from across the nation and the world. As a whole, these studies conclude that increases in short-term rentals within cities and neighborhoods have exacerbated housing shortages, disrupted community cohesion, and dramatically changed the character of neighborhoods. Furthermore, residents within these communities have experienced an increased sense of isolation, alienation, and unfamiliarity with places that they call home. Southern culture prides itself on a sense of hospitality, friendliness, and community. However, unrestricted short-term rentals risk this identity and way of life. The rise of short-term rentals has been shown to increase transient populations in residential neighborhoods, exacerbate rental prices, and decrease the number of housing units available to residents. Oftentimes, this results in the displacement of long-term residents, residents who not only call these places home, but have invested socially, economically, politically, and spiritually. Those who are able to remain in those communities face a different set of challenges, something that academics have coined indirect displacement. Indirect displacement does not remove residents from their neighborhood, but instead changes the physical and social landscape beyond recognition. This continues to threaten the core of the so-called Southern way of life. After examining the previous literature, we turned our attention to exploring the impact of short-term rentals on Davidson County. As of 2021, there was over 6,500 short-term rentals within the county. Of these short-term rentals, 10% were non-owner occupied, 34% were owner occupied, and 55% were multifamily. In our analysis, we considered the period 2015 through 2020, looking at changes in the number of short-term rentals over time. Broadly, our analyses found that short-term rentals are more prevalent in neighborhoods with larger proportions of renters and fewer homeowners. This is important considering that roughly 46% of Davidson County households and 34% of Tennessee households are renters. When conducting our analyses, we also found three important impacts of short-term rentals. First, increases in short-term rentals, particularly in multifamily units such as apartments, are associated with increased median rent over time.
Madam Anderson,
Yes.
you're over your time, so we will stop right now, but please stay there.
Okay, thank you.
Members have questions for you. This time I'll recognize Chairman Williams.
Thank you. Did you say thank you for coming today. Two questions. One, did you say that the population percentage in the area in which you did the research was 41% of the population rented?
46%, so nearly 50% of households.
How does that compare to other cities? For instance, in my community, 52% of my community in my district rent. So 46 actually sounds like a pretty good number compared to some districts. How does Davidson County compare to, or your research area compare to most other cities?
Ms. Anderson?
So we focused most of our research on Davidson County due to access of short-term rental data. It was the only county that we found that keeps the permits that was easily accessible through open access. However, with an increase, we have found that increases in short-term rentals tend to occur within those areas where there are higher number of renters, which tends to increase the median rental prices, especially those who pay 30 to 34% of their income, which is housing burden, their cost burden. So it tends to disproportionately affect those who are renters who already pay a substantial amount of their income to housing. So I assume that in those counties where there's a higher proportion of renters, it would only be more drastic than the impact that we saw in Davidson County.
Chairman Williams?
Do you consider in your study the impact of having institutions of higher learning and the nature of them being transient as it relates to your data. For instance, you have Tennessee State, you have Belmont, you have Lipscomb University, all within a 5-mile radius of each other. The question is do your numbers take into consideration or separate those because they are transient, or are they lumped into that percentage?
Mrs. Anderson?
They are lumped into that percentage. Residents or college students tend to be in communities for 4 years. And so they are less transient than residents or populations who are coming in for just a weekend or a week. And so it has a different effect. That is definitely something that we would be interested in exploring further. But based off of data, it's really hard to delineate what is a resident versus a college student who could also be considered a resident. Like myself, I am a Nashville resident, and I have been at Vanderbilt for 4 years now and plan to continue to remain in Nashville, invest in the community.
Chairman Williams?
Thank you. Finally, your testimony today seemed to mirror or parallel the bill that was discussed in a previous committee. Were you able to see the amendment that he just presented that the committee adopted that rewrote the bill? Because I'm relatively certain that it may not do anything except deal with those grandfathering issues. Have you seen that amendment?
Mrs. Anderson?
I have not, but our research has shown that non-owner occupied rentals, which would include those that are continuing to be grandfathered in, would exacerbate all the different things that I shared. So by allowing those to continue, it would continue to cause all the problems that we have seen in our research.
Chairman Williams?
Do you consider property owners, rights to do with their property, which they purchased it for, into consideration of your study, or is it only looking at the short-term renter?
Mrs. Anderson?
We did not consider it in our current research, but we have seen, or from different previous research, that property rights also include the people who live next door. So individuals who may own houses next to short-term rentals also have the right to be able to live without the disruptions that short-term rentals may cause. And also renters, though they do not have property rights, which is another issue, they are also negatively impacted by this. And so we are looking at, by what you are saying, you are looking at one population and failing to take into account the rights of others who may not have the ability to own property, whose own property may be at risk due to their neighbors' decisions.
Yeah, that would be the case, ma'am, if we weren't taking away the property owner's rights of the person who purchased that property. So what you're suggesting is that everyone else has property owner's rights except for the person who wishes to have a short-term rental on their property, even though they were permitted to do it before.
So we are not attempting to get rid of all short-term rentals. That is not the goal. New Orleans is an excellent case study of how they approach this topic. They have looked to regulate apartment buildings that have been completely turned in to short-term rentals. They have also been looking to regulate non-owner occupied. Non-owner occupied means the owner does not live on the property. We are not trying to take away the rights of those who want to rent out a room, rent out a basement, or rent out like a detached accessory dwelling unit that is on their property. So the goal is not to completely strip the individual of their property rights, but to regulate it in order for the betterment of the rest of the community.
Any other questions for our speaker? If not, without objection, we'll go back into session. We'll hear from Representative Miller.
Thank you, Mr. Chair. Mr. Chairman, for clarification, are we working on the bill or an amendment
We are working on the bill.
on the bill as amended? And I see where we did attach amendment number 2, which exempts several counties.
You're recognized.
Mr. Chairman, yes, my question is to the sponsor. Does this take away all responsibility and authorities from municipalities?
Chairman Faison.
Thank you, Mr. Chair. And the gentleman from Shelby County know this is not deregulating and taking authority away from the local municipalities. What this is doing is the people who originally owned short-term rental and they transferred to their wife, their spouse, or to a trust or back from a trust to them. This allows them to be able to go back and reapply for their permit that they originally had. That's it.
Any other questions for the sponsor?
Thank you.
Leader Gant.
I think you just answered my question. This is only can be transferred between family members. Is that correct?
Chairman Faison.
People that were originally on the deed before they lost their permit, or moving forward, if they do transfer people that are originally on the deed.
Leader Gant.
Okay, but it only pertains to transferring within a family from one family member to another.
Chairman Faison.
This three things: a transfer from one spouse to the other, a transfer as a result of a divorce, a transfer from an owner to a trust, or from a trust back to original owner. So there, people that are related, or that went to a private trust and back and forth from a private trust back to the person. But yes, in the family.
Leader Gant.
Can the private trust be owned by somebody outside of the original family and be transferred to that?
Chairman Faison.
We'll have to consult legal with that. I can't answer that.
Leader Gant, do you want to hear from legal?
Yes, I would.
Without objection, we'll go out of session and hear from legal. Legal, you're recognized.
The transfer money from legal, the transfer provision relating to trust says that a transfer by transfer of real estate to a revocable living trust or a tenants by the entirety trust created by the same transferor or by a spouse of the transferor, or transfers by the trustee of a revocable living trust or a tenants by the entirety trust back to the same transferor or to the transferor's spouse. So I think it is, yes, between spouses.
Does that answer your question, Leader Gant?
Yes, thank you, Chairman.
Any other questions for legal while we're out of session? Seeing Representative Miller
Thank you, Mr.
for
Chairman.
legal.
Thank you, Mr. Chairman. And for legal, I did ask the question, would this legislation take the responsibilities from municipalities? And I think his answer was no.
Legal.
Do you interpret, how do you interpret?
Thank you, Representative Miller. Matt Money from legal. I agree with that. It does not apply to other types of transfers, just these specific three.
Thank you.
Any other questions for legal? Seeing none, we'll go back into session. And Representative Calfee, you're recognized.
Thank you, Mr. Chairman. Sponsor, we've come a long way from what this bill originally did, which was take away all authority from the local governments. How did we get to where we are this morning?
Chairman, you're recognized.
Thank you, Mr. Chair. Representative Calfee, I would say that the original bill did not take all authority away from local governments. It took some. It's a pretty broad stroke. So I would first say that. And then also I would remind you that in the legislature, I call it bobbing and weaving. You navigate a bill and you get what you can get as you move through different committees to finally get to some goal on the House floor. And so I would say from the beginning till right now, we've navigated and brought different amendments that work for each committee.
Representative Calfee.
Thank you. We know that there's one bad actor across the state of Tennessee in the Airbnb business. And of course, thanks to the voucher bill, we can no longer make it apply to just one area. So it has to be a broad stroke across the state. So got just a couple of questions and a couple of statements, if the chairman would allow. Does this take any authority away from the local governments except what you've just stated?
Chairman Faison.
No, sir, it does not. This completely allows all local governments in Tennessee to continue to regulate short-term rentals.
Representative Calfee.
Well, I'm glad I'm not going to have to face this anymore, because as long as Nashville's in the state of Tennessee, this is going to be an ongoing problem, and I won't be here next year. It's been a problem for 10 years now. But let me give you my background a little bit. I've been real concerned about this. I served 20 years on the Rowan County Commission. And I understand about taking local control away, and I don't like it, because local government is best locally. Now, I was one of two people back in the early 90s that voted against zoning Rowan County. None of the citizens wanted it, nobody, except the rich and powerful. And it has helped the rich and powerful and hurt all the small people. A farmer that wants to fix lawnmower engines in his spare time couldn't do that. I was the only one out of 15 that voted no on having a building inspector. And I knew that would get out of hand. I'm going to tell you how out of hand it got. The state law forbids local counties or local cities to selling a building permit for agricultural building. They can't sell a permit, they can't inspect it, but there's cases where they quadrupled the price of an agricultural building. And then me and the Farm Bureau, me working down here in the Farm Bureau, working here and at home, we got that shut down. But it already cost people tens of thousands of dollars unnecessarily. So having said that, I'm for property rights. But as the lady pointed out, if you're causing a disturbance next door, then you're affecting somebody else with property rights. So this is quite a shock the way we changed. So I'm just concerned and I'm going to vote no. Thank you. Thank you, Mr. Chair.
Any other questions for the sponsor? Chairman Faison, you're recognized.
Thank you, Mr. Chair. First of all, we're going to miss you when you're gone. And secondly, there's in current law, if there's a complaint 3 times over any span of time that your permit to do a short-term rental can be revoked. And just wanted to remind you that. And
Representative
property rights is
Hodges.
strong.
Thank you, Chairman. Is the Senate version the same as this? Is there an
Sure.
amendment?
Chairman Faison?
I have not looked at the Senate version, but we have definitely moved this one around substantially from its original. So I'd say it's different.
Representative Hodges?
So if the Senate version passes, are you going to adopt that version on the House floor?
Chairman Faison?
Thank you, Mr. Chairman. Representative Hodges, when a bill makes it to the House floor, it belongs to the body. And I stated to the chairman earlier that I would yield to his direction on the House floor of what he wants to do with the bill.
Chairman Hodges?
So there's no guarantee, though, that the amendment with is going to stand, because the Senate version may kill it. We might go back to the original bill once it gets to the House floor.
Chairman Faison?
Thank you, Mr. Chair. In my short 12 years here, I have watched many a chairman of a full committee get up and speak specifically what has taken place with the bill. And historically, in my 12 years, I've seen the members of the House floor follow what the chairman's leading is on a bill. And as I stated earlier, we will follow his leadings when this bill gets there. And if it's in opposition to what's going on with the Senate, we will yield to Chairman Crawford.
Thank you, Chairman.
Leader Gant?
All right, I'm trying to understand here. So if the Senate passes in their current form before our amendment in the House, and you're saying you would not conform to that Senate version, or you would?
Thank you, Mr. Chair. Leader Gant, what I've stated on record is that I would follow the leading of Chairman Crawford. If this if y'all allow me to pass this out today, whatever this is that this committee has adopted, that will be my intent to happen on the House floor at his leading, because he's the chair of the full committee and we would follow his leading on the House floor.
The reason I ask is I'm a yes vote now, but if the Senate version comes over, I'm a no. So I feel kind of trapped here in this situation. So there's no clarity here. So I mean, I need some intention of what you plan to do when the House floor. Do we conform to the Senate version? Would you recommend that, or would you not?
The chairman will take privilege here. I spoke to Chairman Faison last night on the House floor, and I asked him, would he be willing to send it back if the Senate version or they changed it? And he told me at that time that this become a bill of the body, and he did not feel like he had the authority to do that. At no point have I said I would send it back or that I would do anything with it. Those was your exact words, Chairman. So you can answer that question.
So just to be fully transparent and clear, I'll state again, whatever, when a person, when you look at our rules and a member says, I'll send it back, you don't actually have the authority to send, as a member in the well, to send a bill back. You don't have the authority to do that. And anyone who says they can, they're speaking incorrectly. Leader Gant, what I'm saying is I'm at the will of the body on the House floor under the leadership of the full committee chairman. If he makes a motion to send it back to the House floor, then I'll stand with the chairman of what he wants to do on the bill as whether it's been amended or not amended. That I'll follow his leading from the House floor.
Leader Gant.
All right, let me ask it a different way. If this goes to conference, would you confer to the Senate version?
Chairman Faison.
I would ask for the chairman to be on that committee, and I would follow his leading.
Thank you, Mr. Chairman.
Representative Shaw.
Thank you, Mr. Chairman. Let me take the privilege to ask you, Mr. Chairman, you're from Cock County, right?
Chairman Faison.
Yes, sir.
What's the population of where you live?
Chairman Faison.
36,000.
Representative Shaw.
Thank you, Mr. Chairman. I don't know what Nashville's population is, but I'm sure it's several times more than that. I just wondered, why would you be carrying a bill for Nashville and you live in a neighborhood with 36,000 people?
Chairman Faison.
Thank you, Mr. Chair. Mr. Representative, this bill has statewide application. It's not just a Nashville bill now as amended.
Representative Shaw for follow-up.
Yes, sir, because I was told when it started, it was for Nashville. Maybe somebody gave me the wrong information, but I was told that there was some problems here in Nashville that was trying to get fixed, but it really wouldn't affect anybody else, although I see one of the members have taken out his counties. But now you're saying it is a statewide application.
Chairman Faison.
That is correct. Yes, sir.
Thank you.
Any other questions for the sponsor? Representative Chisholm.
Thank you, Mr. Chairman. To the sponsor, so since Memphis doesn't currently have a permitting process, would you be opposed to taking Memphis out of the bill?
Chairman Faison.
Thank you, Mr. We're at the will of this committee.
Thank you.
Any other questions for the sponsor? Seeing none, looks like we're ready to vote. We are voting on House Bill 0645 as amended. All in favor, please say aye. Opposed, no. No. Bill fails. Next on the list is House Bill 2434. The sponsor has asked that it be taken off notice. House Bill 2536 the sponsor has asked that we send this to special calendar. Without objection, special calendar. Item number 5, House Bill 2911 by Chairman Howe. Proper motion in second. I do see it has an amendment. Can you please give us your drafting code? Drafting code.
You want the code on the small amendment or the bill itself?
Small amendment.
That would be drafting code 017301.
Do I have a motion on the amendment? Motion and second on the amendment. We'll go ahead and put the amendment on the bill to be discussed. All in favor of amendment 17301, say aye. Opposed, no. Bill is now amended. You're recognized, Chairman Howe. Turn your mic on, please.
My mic just went off, sorry. Thank you, Mr. Chairman. Committee, this bill is a private act for Polk County, which is in District 22 that I represent.
The question has been called. We're ready to vote. All those in favor of House Bill 2911, say aye. Opposed, no. Bill moves on to calendar and rules.
Thank you,
Chairman.
Mr. Chairman, committee.
Next on the list is House Bill 2903 by Representative Baum. Proper motion and second. Chairman Baum, you are recognized on your bill.
Thank you, Chairman Crawford. In the year 2020, the city of Murfreesboro sold its electric department to the Middle Tennessee Electric Membership Corporation for an amount, including principal and interest, of a little bit over $300 million. This is a bill that would permit the city to set up a trust fund. Proceeds from this trust fund would be used in the following way. First, 5% of the trust would be drawn down every year. 85% of that amount would be allocated to the general fund for the city, and the remaining 15% would be allocated to some combination of nonprofit or nonprofit entities. This is just a bill that would permit the city of Murfreesboro to set up this trust fund.
You've heard the explanation from the sponsor. Is there any questions? Previous question has been called. We're ready to vote without objection on House Bill 2903. Moving on, please say aye. Opposed, no. Bill moves on to calendar and rules. Item number 7, House Bill 2912 by Representative Baum. You're recognized.
Thank you, Chairman Crawford. This is another local bill. It's a bill designed to enhance the oversight of juvenile detention in Rutherford County. What this bill would do is it would allow Rutherford County to set up a juvenile detention board that would oversee the Rutherford County Juvenile Detention Center, its juvenile inmates, and the director.
You've heard the explanation of the sponsor. Let it be known that I do have a majority resolution of 2/3 vote in my office if anybody needs to see it from the local governing body. Is there any questions for the sponsor? Seeing none, we're ready to vote on House Bill 2912. Moving on, please say aye. Opposed, no. Bill moves on to calendar and rules.
Thank you all.
That brings us back to the first item on today's calendar is House Bill 1201 by Chairman Whitson. Proper motion and second. Chairman Whitson will be presenting from the table without objection. I do see we have some amendments we need to take care of, so I will recognize you, Chairman Whitson, to begin the process of putting amendments on and discussing your bill. You're recognized.
Thank you, Mr. Chairman and committee. First of all, House Bill 1201 is what I call the Campaign Finance and Ethics Reform Act of 2022. It's been a hard work over the past 15 months of citizens, legal advisors, and members of this body. First of all, I want to say the vast majority of members that I serve with follow the rules in regards to reporting campaign expenses and contributions. As I said before, since I've been up here, I've rediscovered a sense of purpose and camaraderie serving with these members that I have not felt since I was in the Army. And then the military is one of the highest regarded institutions of our government. Our intent here today is to increase public confidence and trust in the campaign process in regards to how campaigns are financed and how members are held accountable if they do not follow the law and the rules. Over the past year, we've discovered there are parts of the TCA that needs to change to ensure disclosure and to also to increase public trust in our election process. Chairman Williams and I have been working on this for over a year and a half, and I appreciate his help and support as we work through this legislation. And it's my understanding that Chairman Williams has an amendment that incorporates most of the amendments that I have presented last year in committee and have been working on with the members of the body. And with that, Mr. Chairman, I request my amendments be rode to the hill of this bill so we can hear the amendment that has been filed by Chairman Williams to see where we are in the posture of this legislation.
I need a motion and second to roll these, proper motion and second. Your amendments are rolled to the hill. At this time, I'll recognize Representative Williams, and I need your drafting code, sir.
Thank you, Chairman and members. Drafting code, the amendment drafting code, which does rewrite the bill, is drafting code 17334.
Proper motion and second. You're recognized on the amendment.
Thank you.
Sorry, committee, my fault. This is a untimely amendment, so I need a motion to take this up. Proper motion and second to take up the untimely amendment. All in favor, please say aye. Opposed, no. The amendment is accepted. We will now hear from the sponsor, Representative Williams.
Thank you, Chairman. Before I get started, just want to make sure, do we have to have another motion and second since- to adopt?
Do you want to go ahead and put it on?
Let's do that because
Okay.
I feel like it's important to get it in the constitutional order.
All right, we'll go ahead and,
So Mr. Chairman, I move amendment drafting code 17334.
got a proper motion and second. At this time, we'll vote on adding amendment 17334 to House Bill 1201. All in favor, please say aye. Opposed, no. For what reason, Representative Miller?
Thank you, Mr. Chairman. Just had a question to the sponsor. If the sponsor was in support of this amendment, or does he have an opinion on it? I just wanted to know that.
It was a friendly amendment.
Okay, thank you.
Amendment passes. It's now on the bill. You're recognized, Representative Chairman Williams.
Thank you, Chairman and members. Colonel Whitson, Representative Whitson, I appreciate, you were exactly right. Last year when this bill moved out of election subcommittee, you and I worked diligently to try to find something that works. You are also correct in saying that the vast majority of members of this body adhere to the rules. But what this bill seeks to do, and I think it answers a lot of the questions. The Colonel had 4 amendments, which he filed in this committee, which we have now rolled to the Hill. This bill incorporates 2 of the additional amendments to do that, with the idea of having one concise amendment to be able to do that. So I want to say first, before I go through a section by section review of the amendment, thanks to Colonel Whitson. One thing I found out about Colonel Whitson over the last 15 years, he's still a military man through and through. He sends me more books than I know how to read about every one of his bills. And so I appreciate him and his great effort. But this bill, as it's rewritten and drafted now, in sections 1 through 5, I'm going to go through the sections of it, and it's happy to answer the questions members have. And if we get off into the legal weeds a little bit, I see the purple tide, Doug Himes is here to also help me ask questions. But sections 1 through 5 of this bill, it requires meeting agendas of the Registry of Election Finance of Tennessee Ethics Commission and the Bureau of Ethics Commission and campaign finance to be published at least 5 business days in advance of meetings. As the members know, this is a requirement that we have to do for all of our local governments. This is just a similar requirement that we're going to request for these 3 entities. And it requires large Registry and Ethics Commission civil penalties or those settlements to be approved in a public meeting. So currently, as long as they're in a public meeting, they can make settlements based upon those civil suits that are there. But if it's a large penalty that they have to meet in order to do that. Section 6 of the bill, it removes the PAC blackout period, which was currently found unconstitutional by the courts. And so this just removes that PAC blackout period. Section 7 requires itemization of all expenditures reported on a long form. So in the 12 years that I've been here, I've never had one itemized, unitemized expense on here. As long as you use the long form, you cannot do unitemized. If you use the short form, you still can do an unitemized expense report. Sections 8 through 12, this is an enhanced interim reporting for candidates and PACs of contribution and required contributions and expenditures received during the last 10 days of the election. So this would create another reporting report of those expenditures the last 10 days. As you know, vast majority of funds in elections are spent in those last 10 days, both in a primary and general election. This would require additional reporting for those. Section 13 extends the civil penalty joint liability to candidates controlling or serving as officers of PACs, and it prohibits PAC funds from being used to pay assessed penalties on those PACs. This is an important change. It requires treasurers and the candidate them both to be liable to those civil penalties, and you can't use your PAC contributions to pay for those civil penalties. You will have, if you break the rules and you are assessed a civil penalty, you will pay those fees personally in Section 13. Section 14 requires candidates and PACs to keep campaign funds separate and segregated accounts from other funds, including personal funds. This is not currently stipulated in the code. I did find out there are a few folks who still are commingling their personal resources with their campaign funds. And if this bill passes, then that will not be possible. Sections 15 through 19 revises the registry appointment provisions and requires provisions concerning restrictions on the service of registry and ethics commission members and their spouses. Section 20 imposes enhanced document retention on candidates for audit purposes and requests that audits be completed in odd number years. There was an instance where a member of this body, in fact, a member of this committee, there was a finding in the ethics for him that was unfounded, but it was during an election period. And so this would require the election of campaign finance to expediently make remedy to those accusations or those concerns so that it's not drug out over a long period of time. Section 21 adds members of the governor's cabinet to the list of persons who cannot receive compensation for consulting services. Currently, members of the cabinet can receive compensation for consulting. Section 12 is an enhanced disclosure on single sources of income of $5,000 or more and requires disclosure of member-controlled PACs. Some of the members have PACs that they have both a campaign and a PAC campaign. This requires additional disclosure. Section 23, and I'm more than 2/3 done, my apologies, clarifies that state trial court judges file annual statement of interest disclosures with the Ethics Commission. As you know, judges have a different ethics standard than we do, but this is just this was just an oversight, so we're adding judges as it relates to the statement of interest. Section 24 requires an annual statement of interest disclosed be signed under the penalty of perjury. Currently, it's not a penalty of perjury to sign those. Section 25 bans the use of pre-checked boxes as an authorization for future campaign contributions. So the members or PACs will not be able to send an index card in the mail with a return stamp in there that has the box or the monthly fee already checked for them. Someone will have to actually physically check the yes box. This means that the person is truly authorizing it and someone's not pre-authorizing it for them. Sections 26 through 29 deals with the advisory committee. It adds 2 members appointed by the advisory committee on open government to the Registry of Finance. The appointees must, quote, have a demonstrated nonpartisan interest in promoting government transparency and public accountability in the political process, which is, unquote, which is stated in the language of the bill. Section 30 requires any 501c4 that spends at least $5,000 for communications naming or showing the likeness of a candidate within 60 days of election to be treated as a PAC for the purposes of filing an appointment of the treasurer form and reporting its expenditures. In Section 30 of the bill, it just gives the effective dates are varied for different sections of the bill, so to make it not cumbersome as it relates to those total elections. So that is the entirety of this Reform Act, as Colonel Whitson calls it. So I'm happy to answer any questions that the members might have.
Okay, we'll go ahead and start the list. Representative Shaw, you're recognized.
Thank you, Mr. Chairman. Back to, I think it was section 25, talked about checking the box. I didn't quite understand that. Could you go over that one again, Mr. Chairman?
Chairman Williams.
Thank you, Chairman. Yes, anytime you're in politics, you have a tendency from your party wants to send you mail asking you to contribute to their campaign. I have received in my mailbox from candidates, all Republican. I haven't received one from you, Representative Shaw. Yeah, okay. But those boxes come and they have your name and address, and it says, do you want to do an annual membership, a lifetime membership, or whatever? And it already has the box checked in it. So all you have to do is sign. So what this does, it prohibits the check in the box being already printed on that submission. So thank you.
Let me recognize the sponsor, Representative Whitson, you're recognized.
Yes, thank you. Representative Shaw, is exactly what he said. This keeps people from unsuspectedly allowing a campaign to take $10 out every month forever and ever and ever. It does not allow that. This is only for state elections only. Understand the federal government is also working on that to prevent abuse of particularly elders who do not understand. They want to make a contribution. They make a check on a box, and then the next thing you know, every month they head up for that fee month after month after month, and we're stopping that.
Any other questions for the sponsor or the sponsor of the amendment? Leader Gant.
Thank you, Chairman. Under section 22, can you define single source income?
Who's the question for? I'm sorry, Leader Gant.
The sponsor of the amendment.
Chairman Williams.
Thank you, Chairman. I'm flipping there to that section. So in section, I'm sorry, what section did you say it was again?
21. I'm sorry, 22.
Okay. Okay. Currently, when you do a statement of interest, when we do our statements of interest, which for the members, if you haven't done, it's due on Friday. The statement of interest going forward, which is why we have the alternate date, if you receive a single source of income that's more than $5,000, you'd have to report it on your statement of interest. So for instance, if you have a consulting business outside of your insurance business and you receive more than $5,000 in that consulting business, you would have to put that on your statement of interest.
Leader Gant, follow up.
So somebody that's in, say, my profession, insurance, I receive commission statements from various insurance companies over $5,000. So I would have to list each company that I receive those commissions from on this statement.
Chairman Williams.
It's my understanding that you would have to do that. Yes, sir. So if you work for X insurance company, I want to try to keep names out. If you work for X insurance company and you get a check from them, you're going to put that there. If you're writing insurance for 10 other insurance companies that you're writing policies for, those other 10, if all or any of those are you receive more than $5,000 from those entities, then it would have to be on the list.
Leader Gant.
So if that money comes in directly to me versus into an insurance firm, does that make it different?
Chairman Williams.
Yes, it does make it different. So if you're getting the check, if the check is being paid to your primary insurance and they write a check to you, you would not have to.
Follow up, Leader Gant.
And that would also pertain to any bonuses or any of that as well.
Chairman Williams.
Yes, sir.
Thank you.
Chairman Whitson, you're recognized.
Thank you, Chairman. Chairman Gant, what this basically does, say for instance, to answer your questions, as a result, under existing law, reporting officials who own businesses that provide services to clients in excess of $1,000 are permitted to simply report the name of the company they own as a source of income, rather than the actual names of those providing the income. So what this would do is, say I have a consulting company on the side. The real intent of this legislation is people who pay that consulting company, and I own that company through an LLC or whatever, I have to disclose those clients who spend more than $5,000, or that pays me more than $5,000 a year. Federal officials have to do that now, Secretary of Defense, Secretary of the Army, but also this is to make sure, and if you're a doctor that's privileged, you don't have to report it. If you're a lawyer, that's privileged, you don't have to report it. It's just those sources of income over $5,000 that you have to report, that you receive this. The real intent is to make sure members of our General Assembly, the governor's staff, commissioners, if they have a business on the side and they're doing business with clients, they can influence legislation, they need to report that.
At this time, this makes me very nervous because I don't think very many of the chairmen have had this opportunity, but Speaker Sexton, you're recognized.
Thank you, Mr. Chairman. It's great to be here with you all today. I have a question for legal in this, because there's a lot of information out there about what this bill would do. And so I would like to have their interpretation on what this bill actually does and doesn't do. So to our legal expert on the committee, does this bill at all limit any 501c4 activities, prohibit any communication, prohibit them from doing any issue advocacy at any point throughout the year and during an election?
Without objection, we'll go out of session to hear from legal. Legal, you're recognized.
Thank you, Matt Mundy from Legal. Mr. Speaker, thanks for the question. This in no way prohibits, restricts, or limits the ability of a 501c4 or any other entity from engaging in speech, advertising, mailers, commercials, anything like that. There are, in my personal view, nothing that chills free speech when it comes to 501c4s. We only want them to report expenditures in excess of $5,000 that were made within 60 days of an election. Other than that, they can spend as much money as they want during a campaign, and they can say what they want during a campaign.
Speaker Sexton.
Thank you. Can we go back in session?
Without objection, we'll go back into session.
And to the sponsor. So let me ask Chairman Williams about this. Is anything in this bill require the 501c4 to give out their contributors or their donors?
Chairman Williams.
Thank you, Mr. Speaker. As many of the body in this committee may know, last year I was able to carry a 501c bill or 501 bill, which preserved the privacy of 501cs as it related to their contributors. And this bill in no way prevents those contributors or requires that those contributors names and information regarding 501cs be released. All it states that it allows a level, as legal said, it allows the same level of transparency to expenditures on those over $5,000 that this body and the upper chamber and PACs currently have to operate under.
Thank
Speaker
you.
Sexton.
Thank you, Mr. Chairman. And then to follow up on that, there's also misinformation put out that they would have to be treated like a PAC.
Mhm.
But what this bill does is require them through the registry to list their expenditures only
Mhm.
and not their contributions on any of those forms after they spend $5,000 within a 60-day window of a campaign. Is that accurate?
Chairman Williams.
Yes, Speaker, that is correct.
Thank you. Members, what this bill does in totality, it's all about transparency and it's about accountability. The voters of Tennessee, when you watch all different elections, they want more transparency in campaign finance. They want to know who's behind the money, how they're spending the money, because they're trying to influence the election. And issue advocacy groups can continue to do business just like they've always been. There's nothing in this bill that stops them from continuing to put out whatever they want. All this does is say if you spend over $5,000 within 60 days of a campaign, you got to report your expenditures and bring it from the dark into the light. And there may be some groups who don't like that. I could understand that because maybe they're not doing all positive stuff. Maybe they just want to do negative stuff. But what you do know is if you're trying to do something in a 60-day window in a campaign cycle, you're trying to influence somebody's vote. And the voters need to know, and the citizens of Tennessee need to know who those people are that are trying to influence their vote, just so that they know. Whether it's $5,000, people are getting hung up on $5,000. Imagine someone drops $1 million This applies to everybody the same, all across the board. Doesn't matter if you're Republican, Democrat, conservative, liberal, nonpartisan, neutral. Every 501c4 is treated exactly the same in this bill. It also mirrors the federal on the last 10 days of a campaign, because what happens in the last 10 days of a campaign? There's not transparency. There could be contributions coming in. There could be expenditures coming in or going out. And so what this bill does is mirror what's going on at the federal level within the last 10 days of a campaign. Instead of hiding your expenditures or hiding these contributions and holding off and not being transparent, all this does is say, you can continue to receive those contributions. You can pay for those TV ads or whatever you want to do in the last 10 days. You just have to report it. This bill is nothing more than a mechanism to report and disclose, to provide transparency and accountability. And then the last thing is on the registry. All those people are politically appointed, either by the caucuses, by the governor, the two speakers, which is fine. But adding in two people from the open government side to be the watchdogs and the overseer gives us an added protection of making sure that that board's not political. Because if someone breaks the law, then they need to be held accountable. And the other thing that this bill does, if you do break the law and you're held accountable, why in the world will we allow them to use their political money that somebody gave them to do something political with to pay off those penalties for them breaking the law? So at the end of the day, what this really does is provide transparency and accountability on a lot of people. And unfortunately, sometimes you have to go through bad things to bring things to the light. And so what this bill is an attempt to do is not to harm anybody, but to allow Tennesseans to have a better understanding of how money's spent and making sure that anything in the dark now comes into the light. Thank you, Mr. Chairman.
Representative Manis, you're recognized.
Thank you, Mr. Chair. The only freshman on the committee probably should not speak after the speaker, but I will go ahead. Chairman Whitson, Colonel Whitson, I just, as I've kind of combed through this bill and worked through this process and fielded the hundreds and hundreds of emails and calls, I admire all the hard work that you and Representative Williams have put into this piece of legislation. I hope your district knows how hard you work for them and how hard you work for the state of Tennessee. I admire everything you've done, but especially when it comes to this. So many calls and so many emails, and I'm like, what am I missing? Because in my opinion, it is about transparency, and I would go back and read it, and I'm like, what is it that I'm missing? And I found that I don't think we received one call or email from Knox County or specifically District 18. It was more special interest groups, and they were just overwhelming. So I'm saying all of that to say I wholeheartedly support this piece of legislation. I can see it doing nothing but bringing transparency to the process. So I will be in total favor. And again, I am grateful for everything you've done for the state of Tennessee. And thank you for being a true friend to me.
Any other questions? Representative Miller.
Thank you, Mr. Chairman, and thank you, the Speaker, and Chairman Williams, for clarification and understanding. I'm not as familiar with 501c4s, but through this transparency, will the individual PACs or organizations, those that come under the 501c4, when they declare who they are, what would that include? Names, addresses, phone numbers? We know exactly who these individuals are.
Colonel
if they
Whitson.
go over the $5,000.
Colonel Whitson, you're recognized.
Thank you, Mr. Chairman. Let me get to that section there. So as the speaker explained, this does not, only if they meet that $5,000 threshold, would they be required to identify themselves on a campaign report, much like a PAC, the name of their organization, their address, and the amount of money they spent.
And that's the extent of that. That would be the extent of their declaration.
Yes.
Okay, thank you. Thank you, Mr. Speaker.
Representative Shaw.
Thank you, Mr. Chairman. I just, prior to the last speaker, the last call I got this morning, I answered the phone and I shared this with the group. And the caller said, this is going to infringe upon my freedom of speech. And I said, no, it's not. And after some discussion, finally, the caller just simply said, well, even if it doesn't, I don't like the bill. So I think that's where we are. We're trying to report and be transparent, which I think we should be, and I'm in support of your legislation. But I think it's just some folks out there just don't like the bill. But I'll be voting yes. Thank you.
Colonel Whitson.
Thank you. And again, it's changes stuff on folks. So if they don't fully understand the contents, it is a comprehensive bill. There's a lot of sections to this, but it will make us a better body up here if we adopt this. And also it will keep the public informed, especially within the 60 days prior to election. I can give you an example. We have a election coming up on May 3rd, a county election. Already some 501c4s are involved in that election and putting information out on social media promoting the good deeds of a candidate. The 501c4s cannot say vote for or vote against an individual, but they can put out information and they can still do that. The whole time that Chairman Williams and I were working on this, they never entered a thought that we would prohibit them from doing what they're doing now. And so with that, it's just a disclosure requirement.
Representative Hodges. You're recognized. Question has been called on the bill. Without objection, we're ready to vote on House Bill 1201 as amended. All in favor, please say aye.
Aye.
Opposed, no. Bill moves on to special calendar. No, I'm sorry. Finance. Moves on to finance.
Mr. Chair,
Mr. Chair. Colonel Whitson, you're recognized.
Again, I just want to thank Chairman Williams. We have a saying in the Army, we give to lieutenants or captains, say, move out and draw fire. And he got that order this morning pretty early. And I just want to compliment you for the great job that you did, Chairman.
All right, members, we've still got business to conduct here. At this time, I'll recognize Representative Carr.
Thank you, Chairman Crawford. I think we're ready to take up this special calendar at this time, and I know we've already been through all these already, and they've been decided on some. So if I may, I would like to make a motion that we send all the bills. Well, I stand corrected. Make a motion to adjourn.
So moved. We are adjourned. We are adjourned to the call of the chair.
Sweet, don't forget.